I'm here with Clare and Mike Kiely, and we've been discussing flexibility of the planning system and moving from the concept of a scheme to its construction. One thing I thought was quite interesting in the discussion that followed was the analogy with the enforcement system and looking at this from the point of view of does it really matter? Mike, in particular, you've mentioned your use of enforcement notices in the past and to under-enforce and looking at something as to whether it's expedient to enforce or not, and could the same principles be applied for scheme changes?
Yeah, and I think the point was made by John Walker in the audience to not to forget the concept of de minimis. So I think it's about considering the nature of the change, and there's a whole spectrum from de minimis to minor to material to it goes beyond the spirit of the original consent. And I think we've got a range of tools, as you say, the use of enforcement being one that's not commonly used. But I think the fundamental thrust of our paper is that there is a need for flexibility in the planning system, and it should be an intrinsic part of it. And the system was never designed with that in mind, and attempts to introduce it are being partial at best. And we feel that there should be a proper regime, and we outlined what that could be in our paper.
I second that, and the kind of thing that we have in mind would involve a sliding scale, if you like, of consultation requirements. So starting at 96A, which has no consultation requirements at all, up to a whole new planning planning application, which obviously does. There are several staging points on that continuum where you could create a regime for making sensible amendments in a sensible and proportionate way.
I mean, key to your suggestion for reform and also even the current system is this exercise of discretion. Do you think the government could do more in hand-holding local authorities through the process?
I think they can, and when I've discussed this with officials at DCLG, they're rather uncomfortable with some of the concepts. It goes to the heart of the consent and those types of things. But if you look at the range of planning powers, it is littered with those sorts of concepts. The expediency of taking enforcement action and the concept of de minimis. So I think all we're sort of saying is that we need to sort of expand those into this range of circumstances that can apply to an amendment, and then what the appropriate response from the authority is. And if it's all brought into one place with a single procedure perhaps, and then good advice around the edges of it where you're in the de minimis territory or not, then it starts to make sense. At the moment it's all rather disparate. You've got section 96A, you've got section 73 in terms of the core of what it does, and then you've got the government's use of section 73 to deal with material amendments or minor material amendments. So it's a bit of a mess, and everyone is struggling with it, and frankly to some degree we're making it up as we go along through case law, and that's never a great place to be in my view.
It's a real it's low-hanging fruit actually, I think, for the government, because short of legislative change, they could issue some form of guidance to try and not homogenise, but to try and get some kind of consistency between how planning permissions are phrased, how they're crafted, how they're structured from across boroughs. So you can have much more predictable outcomes from the Section 73 in particular process, because the ability to use the statutory means that do exist are crucially dependent really on how the planning permissions are framed in the first place, which can create very, very unpredictable and very, very odd results from borough to borough. In my talk, I gave an example of two neighbouring boroughs in London where there were actually broadly similar schemes, both held to be regenerative, politically both desired by the boroughs in which they were located, and yet the experience that we had of using the same legal power to amend them was vastly different in both cases, in each case. should say.
You also mentioned that with one of those boroughs you actually used mediation to resolve the differences between yourselves and the authority on the extent of changes. How satisfactory was that, and could that be used?
It was very effective, actually. It was very effective. It was mediation, of course, in the course of a court case, because we'd made an application to the High Court for a declaration that Section 73 was an appropriate way to deal with the changes to the scheme that we were seeking. And so the mediation arose sort of in that context, but it does show you what can be done with those kinds of processes, provided both parties are willing to play ball. I think there was a 10 or 15 years ago or so, wasn't there? There was an attempt to launch mediation more widely in the planning system, which I think never really got very far, but it is a potentially powerful tool, I think.
And both of you talked about the importance of structuring applications and decision notices carefully, and the possibility of developers and local authorities working together. I wonder in practice how often that happens. Like, my experience is quite haphazard. Some do, some don't. Some get very worried about the risk of public perception and legal challenge. What's your experience?
Well, I think there are good planning authorities and bad planning authorities, and there are good developers and bad developers. And certainly, I've always, in the authorities I've worked, been keen, to work with a developer to, deliver the development that the area needs. And in fact, the MPPG requires us to do that now. So you could argue that any concerns you might have had before March 2012, you can now put to one side, because you have that direct requirement in government guidance to do so. But I think, the way I look at the whole process is that I say to developers that they should come to a slightly tongue-in-cheek before they put pen to paper, because it's about being part of their design team and working through the process so that we understand each other's briefs, their brief in terms of what their clients' requirements are, our brief in terms of the development plan and the planning authority's requirements. And the earlier you see if you see the process as one of aligning those briefs, then the more likely you are to work together to sort of shared aims. The developer goes off and does a lot of work and then comes to see you with their nice scheme. You may have two problems. One, the scheme might be wrong, and you've got to persuade them to spend a load more money to come up with the second version. So that's how I approach it, and most developers will say yes and want that sort of process, but others don't. They still come to us with very detailed, worked up schemes, and then expect to have a pre-application process, and it's not the best way to do it.
We've enjoyed working with one another, actually, Mike and I, because we came into this process, into this talk, with the idea, I think, that we would have very contrasting, maybe even opposing points of view about how these provisions do work and should work. And actually, we found that we were in agreement with a great deal of the material that we were talking about. And a successful development is a successful place, as Mike said right when he started speaking.
And I wonder how far back can we go in terms of ensuring flexibility in the system. You've talked about preparing applications carefully. Is there a case for saying that actually, in terms of the culture that the local authority creates and the planning policy it brings forward, it can anticipate the need for flexibility?
Yes, I touch on this point in the intro on my paper, although I didn't develop it anymore, because I think it's sort of we could go on forever on these subjects, but it is very, very true. Obviously the council's policies have to be evidence based and delivering their vision, the strategic aims for the area. And they need to be appropriately crafted. But the example I gave is that within Croydon, where I worked, there was clearly a need to redevelop the central retail offer, which is the Whitgift development. But at that stage, we didn't know how that was going to come forward. It turned out that Westfield and Hammerson went into a joint venture to bring forward a complete redevelopment, but it could have been many, many other options. So rather than being very specific in our policies, all we did was to put down a few urban design principles in literally a sketch, with, to demonstrate how any scheme should come forward. So there was sufficient in there to give a clear indication of what we wanted, but we weren't going to be over prescriptive because we didn't know exactly what was coming forward, and it's important to get that balance right.
Claire, Mike, thank you very much.
Thank you.